好，齊人啦。咁呢一個嘅
We have a quorum. This is the third meeting of the Bills Committee on Inland Revenue Amendment Number 7, Bill 2018. We now have a quorum. We first invite the administration in. Welcome. Today we have officials from the FSTB, Inland Revenue Department, and the Department of Justice. I would not introduce their names one by one. CB brackets 1402/18 to 19 brackets 01 has been tabled in front of you. This is the administration's responses to the written submissions received and views expressed by deputations at the last meeting. A summary of response has been compiled in the table, and there are altogether 29 items, and some deputations supported the bill. So I first invite the administration to walk us through their response before I open up the floor for questions. Mr. Lai, Deputy Secretary. Thank you. Thank you, Chairman and members. I'm pleased that we are proceeding to the scrutiny of this bill in the new year. Our response covers 4 main aspects. And as you might recall, there are 5 main parts to the bill. First of all, which is a key part of the bill, aligning the tax treatment of financial instruments with their accounting treatment. And these correspond to pages 1 to 10 of our response. Before the Christmas break, there was a public hearing. We took in views from the sector as well as individuals. They generally supported the bill. The reason is that for financial institutions, if a fair value approach can be adopted for taxing the financial instruments, their tax reporting procedures would be made easier. But when we look at submissions and views from deputations, some of them mentioned that under the new reporting guidelines, the credit loss or losses could be subjected to different approaches at different stages. So the bulk of the amendment is to utilize the fair value basis in response to an earlier judgment from the Court of Final Appeal. We are not attempting to introduce a new policy. Under the Inland Revenue Ordinance, the IRD has always allowed tax deductions for bad debts or credit impaired losses, and we will continue with this arrangement. At the moment, we see no need to put in place tax deduction arrangements for credit impaired losses. So for the 3 stages of expected credit losses, few jurisdictions would have allowed tax deduction for all 3 stages of ECL. And for pages 4 to 10, they were views from different deputations. They would they would like to see clarifications to the legislation, and in the departmental information note, more information would be made available. When this bill is passed at LegCo, the DIPN would list out in detail the administrative guidelines. I'd like to call members' attention to item 9 on page 6. We would take on board one of these suggestions, and we would propose committee stage amendments under item 9. The definition of specified financial reporting standard under the proposed section 18G. The amendment bill specifies that taxpayers and companies can adopt the International Financial Reporting Standard 9 or the Hong Kong Financial Reporting Standard 9 and either of the two can be adopted as a means of fair value basis, and some overseas company might adopt an equivalent of the IFRS 9. If this is accepted, overseas companies compiling reports in Hong Kong might benefit. So by the time we discuss those CSAs, we will give more on that. So on page 11, that is the beginning of our second part. And we propose allowing the deduction of interest expenses payable to overseas export credit agencies. And one of the deputations want to clarify whether the interest expense paid to the Hong Kong Export Credit Insurance Corporation is tax deductible in the foreign jurisdictions. As far as we understand, the HKECIC is not a loan facility provider. It only offers insurance protection, and there is no loan arrangement.
On page 11C, regarding the refining the provisions that implement the arrangement of automatic exchange of financial account information, amongst the deputations, they had commented on this, and we had provided some feedback. The deputations have two views. First of all, do we need to comply with OECD standards and make amendments? And where we have the common reporting standard introduced into Hong Kong, including taking the financial NRFIs such as MPF, mutual credit unions, whether they should be included in the list of reporting financial institutions, and can we also add some flexibility in the wording? So if legislators have experience in our AEOI legislative amendment, the CRS is set by the OECD. They want the different tax jurisdictions to comply fully with their guidelines, and they want their tax evasion measures to be more effective. So the OECD will look at our arrangements, and they have looked at our legislation and feel that there is some deviation from their expectations. So, given the background of international cooperation, we have put forward these amendments. Moving on to page 14 of the Chinese version, where we have visiting scholars and the avoidance of double taxation. We understand that the academia support our recommendation. Of course, there are some queries whether we will have double taxation, and as we explained previously in our meetings, there is a chance of this happening, and we need to comply with OECD regarding the avoidance of double taxation, and we want to avoid dubious tax practice. So that is a brief introduction to our paper. If members have questions, we're very happy to take questions. Any questions from legislators? Well, if there are no questions, I have some. And these questions are revolving around credit. I'd like to have some discussion before we go into clause by clause, because we had raised some questions regarding 18K. So first of all, the government, can you explain credit impairment, the idea of credit impairment? And in our previous two meetings, a lot of participants had mentioned the credit loss in the three phases. Which three phases are those? Could you clarify the concept, Chairman? Let me defer to the Inland Revenue expert. Chairman, in the financial reporting standards, the adjustment loss has three phases. The first phase is within 12 months, where there is a chance of a loss adjustment, and the second phase is the note, the lifelong impairment of the note, of the financial note, and the third phase is actual, where we have credit adjustment, where the credit impairment. So it's under specific conditions, and the conditions are similar to typical write-offs or bad provisions for losses. So, okay, the expected credit loss, does it only affect the notes and bonds or credit loans, financial institutions? So if you use the credit impairment concept, that would affect debt instruments. Is that conceptually correct? Thank you, Chairman. Chairman's understanding is correct. When you amortize the cost, or when you use a consolidated fair value assessment, it is typically revolving around debt instruments. So equities can be handled through the profit loss statement. So I see the whole legislation where credit impairment is where you allow for tax deductions. Is it because that the bad debt is confirmed and therefore you allow for deductions? Is that the case? Chairman, there are actually two scenarios. In the financial standards, they have cases where they defined as a credit impairment. So if you have activities or behavior that is contravenes the contract, and we also have selective actions when we want to have a common standard in dealing with these scenarios. So if you use fair value, or if you use the traditional realized profit to settle your books, they should end up with the same result. So if there are debt between commercial institutions in a normal situation, so they would have bad debt provisions to allow for deductions. So it's not too relevant or related to the credit impairment. So if we have B2B contractual agreements or debt, well, there is no difference in the actual outcome. But I want to point out, if you use the realization basis, they don't want to use fair value calculations, then you have to refer to 16(1)(d) of our current legislation. If you use fair value to enter the books, then they'll have to make reference to 18K3. Well, if they use fair value accounting, but the creditor has it booked in the debt in the balance sheet, if it's just a debt relationship between the two companies, so the debtor goes into liquidation. Under that scenario, it could be viewed as a lifelong impairment. How will you deal with it? If the debtor has been liquidated, how will that be handled? Thank you, Chairman. Well, let me explain. Under the existing tax laws, when can your expenses be deducted? That is when there is a taxable profit. You can have deductions. So in provisions and that, your account receivables, you have sold some goods. The account receivables are booked, but then it can be written off as bad debt, and we also have debtors and creditors. The creditor, in that it is viewed as trading stock in the tax regime, so that can be deducted. So if the parent company and the subsidiary have a debt relationship, it does not generate profit, and even if it's written off, it cannot be they cannot be given tax deductions. What about trade debt? Goods have been sold, and the account receivables are outstanding now, so it affects financial instruments. But debt being a trade debt, is it a financial instrument, and do you have to choose actualized profit or fair value or current value to deal with this taxation item? Will it affect normal trade debt? Well, in the latest accounting financial standards, financial tools, they include account receivables. Okay, I understand. Any more questions? There's only, aside from chairman, there's only one member. No questions? Legal advisor? One view, fair value, how should it be translated in Chinese? The Chinese, as proposed, is 公平价值. And we note that it's also the same Chinese term is used in the banking ordinance, but in the website regarding the rich cheer investment, they use the different Chinese term 公完价值. That is in the Inland Revenue website. So, are we talking about arm's length? No, we're talking about the nice chair case. Chairman, let me answer that. Thank you for noting that. I had also missed that phrase. In the website, we used the 公完价值, and the translation is different from our current version. So, after we have endorsed the law, we will amend our Chinese term in the website. Well, if members have no questions, then we can continue with our clause-by-clause work on the last occasion. So we will be using the blue bill and the marked-up copy to continue with our clause-by-clause. We had stopped at 18K. We had not started 18K. So in the marked-up copy, page 008, 18K, paragraph 1, it says that if the applicant had used a fair value basis, then this would apply. In subclause 2, if the person in respect of a financial instrument that is not credit impaired is not deductible. And subclause 3 says if an impairment loss is recognized by the person in respect of a financial instrument, then it has to fulfill conditions A and B. The first being that the instrument represents a debt that was accounts receivable in a trading receipt. And in condition B, the instrument represents a debt in respect of money lent. So other conditions are covered in subclause C. The impairment, in any other case, the impairment loss is not deductible. And clause 4 says a deduction of an amount was previously allowed to the person for a year of assessment, and the recovery or of the asset value has increased. The increased asset value is taxable. Well, I want to ask if a company bond, a listed company bond, in the contract, the credit rating was an A plus, then all of a sudden the performance dropped and its credit rating became a B or so on, and the bond price fell. So if we use normal, traditional realization principles, then they cannot be tax deductible. But if we use fair value basis, it is deductible. Well, Chairman, it will depend on actual circumstances. So if we use the existing legislation, if your bond is traded for profit, then it is part of trading stock. So whether the price goes up or down, so when the price has fallen, it is reflected in the profit. But when there is a rise in value, then the nice cheer precedent kicks in. It is not realized and you cannot tax that. Well, if you use actualization principle, then it is a provision and is treated as a trading stock. Well, it's a current asset or capital asset. Well, if it's a capital asset, then whether it goes up or down in price, it's capital in nature and there are no tax outcomes. So, okay, we can continue. Thank you, Chairman.
Subclause 5 refers to the purchase of a financial instrument or origination if the instrument is already credit impaired and that the instrument is on revenue account. Any future gain would be taxable. As for subclause 6 or subsection 6, the scope is rather narrow and there was some misunderstanding by members. Subsection 6 lays out that if the person or transferor being a financial institution transfers to another person, that is the transferee. And if there is a transfer of a credit impaired loan with a loss allowance, and that the transfer is not by the way of a buy or of a purchase or sale. One common example is some company mergers. We can see that the transfer transfers a credit impaired loan, and after a merger, it would become one entity. So how would we tax the credit impaired loan? And with the formation of a new entity due to the credit impaired loan, if there is a profit, it would be taxed. So this is the scenario we are applying. Subsection 7 lays out that if the transferor and transferee are in the business of lending money in Hong Kong, then deduction would be treated as having been allowed to the transferee. And subsection 8 explains that if the transferee is not in the money lending business, the amounts of money would be calculated based on the transferor. As for the transferee, if there is a purchase, then the value would then be considered. So this is the design of the arrangement. The scenarios under subsection 7 or 6 to 8 only apply to specific scenarios such as mergers of two banks. These only apply to mergers but not acquisitions, right? So if there is money consideration, then it no longer applies, correct? I will move on to page 11 of the marked up copy, that is clause 18L or section 18L. These apply to derivatives, preference shares, non-arm's length loans, etc. According to 18L, it would only apply if a person has opted for fair value measurement, and one common example is the ordinary shares of an equity instrument. For an equity instrument on revenue account, if it is included in the OCI, technically it would not be reflected in the P&L. It would stay in the OCL. Let me repeat that. For an equity instrument that is also a trading asset on revenue account, and that if it is included on OCI, it would not be reflected in the P&L. And our approach would be like Singapore. Even if the relevant instrument is on OCI, there could be tax deduction. So this is an exceptional scenario. Subsection 3 describes the instrument issued, and there could be gains and losses due to the accounting approach. If the relevant instrument is on revenue account 3A, if this scenario applies due to redemption or purchase, then subsection 4 or 5 would apply, and that is any gain would be taxable and any losses must be deducted. Subsection 6 describes an instrument, and there are special treatments due to the accounting standards. if the person issues a debt security and the debt security is issued with an embedded derivative, and there are two parts to the embedded derivative, and one component is the equity derivative. So one part is the debt and another part the equity component. The equity component should not be treated as interest, and there are similar provisions in Singapore. We made reference to Singapore when we drafted the bill. And if there is a security with no equity component, then this would not apply. This only applies when there is an equity component, and under the DIPN, we would explain to the trade that the scope of application of this provision is very narrow. Section 7 or 8 have to do with preference shares. They would not be considered instruments unless they are converted. And according to Section 26 of the IRO, equity dividend would not be taxable. And under Section 26, the receiver would not have to pay tax. And Section 8 says that Section 9 has effect without affecting the operation of Sections 50AF and 50AAK. So Section 9 describes that the arm's length principle would not apply. This applies to cross-boundary loans. Under the existing legislation, the transactions do not include local transactions, so these apply to cross-boundary transactions. This is not an independent person, and we seek to clarify that the contract interest would be used, and there would be transfer pricing arrangements between Hong Kong and other jurisdictions, and there would be adjustments based on the interest rate. For subsection 9, you were describing non-arm's length scenarios, right? Yes. The contract interest rates might be higher or lower, but you would adopt the same interest rate, is that right? Under the fair value approach, we would use the effective interest rate. And this is an accounting principle, and according to the law, the contractual rate would be used. If the person involved decides to use the fair value approach, and for non-arm's length transactions, we would request the use of the contractual rate. And different jurisdictions would look at the contractual rate rather than the effective interest rate under the accounting principles. Subsection 10 applies to hedging instruments. Capital assets would not be taxed if there is a hedging instrument which is a capital instrument, and if it is arranged in good faith, it would not be taxable. Would there be any cases in which the nature of the hedging instrument is different from the principal instrument? Would there be cases in which a trade instrument is used to hedge a hedging instrument? Let me give an example. If a company imports a machinery from UK worth $10 million, it must be paid in pounds. a forward contract might be drafted via a bank, and it might look like a trading transaction, but we would look at the whole scenario. If we see that the forward contract is in line with the machinery purchase, we would not tax the forward contract. So you would look at the entire transaction before you determine the nature of the hedging instrument. You would not just look at a singular instrument. All right. So that's all for part 2. Any questions? No, we would move on to part 3. We are at page 14 of the marked up copy. This is the beginning of part 3. I'd like to declare interest. I took part in the lobbying work of the HKECIC, even though I had no direct or indirect pecuniary interest. All right. We now move on to page 15 of the marked up copy. There is currently a definition for overseas financial institution. We have added the part A2, an overseas export credit agency. And the discretion of the Commissioner of Inland Revenue has been retained. And in some cases, he or she can choose to not recognize an overseas financial institution. And page 16. Some of the terminology is already in the IRO. For example, controlled entity is in use in section 58 of IRO. A controlled entity refers to an entity wholly controlled by the state. An export credit business is a business to support and develop international trade by providing financing support to exporters or investors of that jurisdiction for export or investment activities outside the jurisdiction. For governmental entity, and in Part D, we would make an amendment so that there would not be any redundancy. For export credit business under the bill, it must involve a loan, but not just guarantee. So a loan must be provided to the exporters, importers, etc.
業務咧，
The export credit business that is conducted by export credit agencies in overseas jurisdictions, they would do loans, but they don't take deposits. In Hong Kong, they don't make loans. So, integral part that is found in existing legislation 50A. We also have a definition for overseas export credit agency. So it means an organization that is owned by or was established and is operated by a government entity of a jurisdiction outside Hong Kong for the purposes of carrying on export credit business. So the commissioner, his discretionary powers are retained on page 0017. So in banking or deposit taking outside Hong Kong, the commissioner's concern is that these are not proper banks or financial institutions. It is a transaction from one entity to another. So the discretionary power we've retained here is that the commissioner may deny or may not recognize them unless there is supervision and they have a proper regulatory regime, and they can be accepted. So, Chairman, I now move on to Part 4, the Automatic Exchange of Information, AEOI. On page 0018, we added a definition, 2020 covered institution. The OECD looked at our legislation, and OECD's view is that the 5 classifications do not comply with OECD. They need to. Let me interrupt a little bit. The 2020. What are the implications of 2020 covered institution? It means that the information related to 2020, the information is generated in 2020 and it has to be reported in 2021 because the OECD feels that the 5 institutions, 5 types of institutions, they comply before 2020. We are trying to lobby with the OECD, but the OECD did not accept our case. So the institutes are MPF, ORSO, and the polling agreements, and CD, those are covered in paragraph CDE. These are the mutual aid societies, and we don't make a lot of changes here. We are just rewriting the definitions to comply with OECD requirements, and we clarified one point that the legal person will make some inclusions. It will include controlling person. There we have the entity A as a non-natural person. If they can enter into a contract with a financial institution, the customer relationship, then that is viewed as an entity. The second one, under existing law, where we have legal arrangements, and B also exists. We have owner incorporations, trustees, protectors, enforcers, and so on. So we hope to satisfy OECD's requirement, and we want to clarify the entity includes legal persons. And in Hong Kong local legislation, we don't have that concept, and therefore we have a footnote explaining that entity reflects the CRS. It covers a legal person and a legal arrangement. So the OECD requires Hong Kong to make that clarification. Okay, thank you. Then I'm on page 0021. This is a consequential amendment. It's something that we need to do on the side because in 2017, the automatic exchange of information, it has to be exchanged in 2018. And we have 5 types of reporting financial institutions, and they have to exchange information from 2020 in 2021. So we need to have 2 sets of information, one set for the old and one set for the new requirement. And we have, therefore, the consequential amendment. So I want to I want to clarify, when you refer to prior accounts, do they need to submit this? The financial institutions that need to report in 2020, they have to submit information from 2020. Please continue. In the prior accounts from 2021, there are 2 parts. The contents are exactly the same. When we refer to prior old accounts, it is an institution 2020 covered institution. These are accounts from 31st of December 2016, and the rest is the same. For example, in page 22, we have Roman numeral 3, 4, and 5. So it's just cut and paste. Now, regarding the reporting year, in page 0023, we have 2 parts as well. I explained just now, some of the work is done in 2018, but some jurisdictions regarding old institutions, they should have done the work in 2018. But regarding our 5 classes of institutions, it will be done in 2021. For so new institutions, we have B. Therefore, it will be reflected in 2021. On page 0024, we have included FATF recommendations. The definition here, we will see a definition later regarding the investment entity, and we mentioned FATF, so therefore we need to have the definition here. That's also a requirement of OECD. And then we move on to 0025 in paragraph 6. There's a definition of controlling person. On page 0026, we have included Roman numeral 4, 5, and 6. That is in line with the Common Reporting Standard minimum requirement. On page 0027, we have repealed paragraph 8. That is the Secretary for Financial Services and Treasury Gazette. This requirement is placed somewhere else. Please hang on a second. On 0026, C Roman numeral 3, the protector of the entity, that has been amended on 1st of January. It reads as protector or enforcer. The legal advisor had noted that that is correct. The enforcer appears in the latest version. Please continue. So on 0028, we have the investment entity. It is reflected in 13AA. It says that in relation to the definition of investment entity, we have to refer to the FATF requirement. So OECD requires Hong Kong to comply with the FATF standard in dealing with investment entity. So that's why we've included this. On paragraph 15, we need to subject to paragraph D the reporting financial institution, and even though the financial institute is not a tax resident in Hong Kong, is not a tax resident in any jurisdiction, and and it was formed and registered in Hong Kong, or if the management was conducted in Hong Kong, or if it is subject to Hong Kong regulatory regime, then we added D3. That is what the OECD requires. So financial institutions who seem to not have a tax resident status, but if they are regulated by Hong Kong, then they have to report according to requirements. We've also added paragraph 16A, where the Secretary for Financial and Treasury Services, they can, through the Gazette, make an announcement and amendments. The government has confirmed this will have to be vetted by the LegCo through subsidiary legislation. And on page 0030, we have guidelines. Well, I want to ask, first of all, the guideline status. It's not a subsidiary legislation, and the guidelines we have a lot of DIPN interpretation. Are the two equally valid, or do they have the same legal status, or do taxpayers have to pay more attention to guidelines? And previously, the Inland Revenue do you issue other guidelines? I want to know what is the difference between guidelines and DIPN, and in terms of the taxpayer compliance, what do guidelines and DIPNs require? Thank you, Chairman. Let me give you some background information. Currently, the Inland Revenue has guidelines. These are for financial institutions. I recall it's some 80+ pages, and it is for financial institutions. It's not for taxpayers because it is not directly related to taxable income. This is a requirement of the OECD. So local legislation, when it's interpreted, they have to align with the CRS of OECD, and we've built a bridge. The Inland Revenue Commissioner will draft some guidelines, and these guidelines are in accordance with the Common Reporting Standard of OECD. We have adopted that. So these guidelines are for reference. It does not give a legal status, but when the courts interpret the local laws, they can make reference to the guidelines. So the purpose is to satisfy OECD. The OECD wants Hong Kong laws to align with the Common Reporting Standard, and we need to build a bridge through these guidelines to satisfy OECD. And honestly speaking, the OECD have read these pieces of legislation. So you have to build something in called a guideline, because this guideline is not for your average taxpayer. So you need this special 50L guidelines. Your previous DIPNs were for all taxpayers. But when you none of this has any legal binding impact on taxpayers. Any questions? If not, we continue to scrutinize 50L. We have a definition for CRS in 50L. Talks about the CRS publication and the Common Reporting Standard. On page 0031, we have the CRS publication.
Part 8
There's another definition called Part 8A, related provisions. This means any provisions of Part 8A and Schedules 17C, 17D, and 17E. Again, the Secretary for Financial Services and the Treasury may, by notice, publish in the Gazette, amend the definitions of the above terms. Legal Advisor, subsection 1 of Section 50L says that the Commissioner may publish in the Gazette these guidelines. We confirmed with the Commissioner that the guidelines would also be uploaded to the IRD website. As for subsection 5, the Secretary for Financial Services and the Treasury may amend the CRS publications, and such amendment is subject to electrical scrutiny. The OECD specified the requirement to publish the guidelines in the Gazette. In many jurisdictions, this is not necessary. And like I said, the DIPN did not need to be published in Gazette. So what is the objective of Gazetto? So I'd like to know why there is such a requirement. Under subsection 1 of section 50L, the Commissioner may publish in the Gazette or in any way the Commissioner considers appropriate, so the existing practice is still allowed. Mr. To, assuming we repeal section 50L, what would be the drawbacks? So is section 50L absolutely necessary? Deputy Commissioner, as I said, OECD looked at the provisions and they felt that there should be a connection or alignment between Hong Kong's legislation and the CRS publications. The OECD looked at these provisions and they felt that the objectives can be achieved. We hope that Hong Kong can pass their review, and as such, we find section 50L appropriate. Mr. To, why would you have such concerns? Let me put it this way. There are common reporting standards as well as CRS publications. So should we get rid of guidelines published by the Commissioner? So do you want to include them in the main legislation? You said guidelines would be published and there would be publications. So there is redundancy. You said you were worried that their standards are not being followed. So if that's the case, you can simply publish the guidelines by the Commissioner and include all their requirements. In other words, you should not add anything yourselves. So would that work? Well, that might not always be the best approach, but it might be appropriate in this case. For some laws, for example, on global cooperation or anti-terrorism, sometimes we would come up with our own provisions. I asked why they phrase it that way. They saw, they looked at the convention wording. So would the would other convention parties accuse us of not meeting certain standards? And you said the answer is no, because they are very lax. They also cited other reasons. For instance, Singapore is adopting the convention. It is also a common law jurisdiction. They have adopted it for a very long time and they had no complaints, so we should just copy what Singapore is doing. We are adopting the Hong Kong laws because there are a lot of interpretations under the common law. There were a lot of cases So you are coming up with your own arrangement, and the people might say their standards should be followed. The trade practitioners would often refer to your guidelines. So would you just copy all the guidelines and say that they are the commissioner's guidelines? So is this a good approach? Or else you might come up with your own system, and there could be confusion. So can the OECD's guidelines be directly quoted without asking the IRD to come up with anything? The bill mentions the CRS publications. There are two parts. One, the common reporting standards and the commentaries. The document has about 300 pages. And number two, for the relevant handbook, it has about 180 pages. So both documents total about 500 pages. For Hong Kong's AEOI provisions, some of the wording was copied from the common reporting standards. We only copied the crux of the provisions. We did not copy the full 500 pages. In fact, not every one of those pages apply to Hong Kong, because the OECD offers some flexibility to the jurisdictions. So in 2016, we extracted some of the crux of the reporting standards and incorporated them into our bill. And can you promise that our commentaries would be followed? And 50L is a response to the OECD, and they accepted our recommendation. Mr. To, Chairman. Please remember that all these is done to facilitate convenience for 51L and B. While let's say if someone has read the two full documents, and if there are questions, the remaining 400 pages would be looked at. This is something they have to do, right? Chairman? For financial institutes with, well, they can simply refer to our guidelines. I don't understand why the OECD was wary of some of our arrangements. Can you give any examples? Why are they so scared? And under the bill, the new FIs and provident funds would be included, and according to the commentaries of the standards, we can see that there's a difference in our interpretations. That's why they hope that the public and LegCo would understand the situation and add appropriate provisions so that in the actual execution there could be an interface. This should be included on the main legislation on the targets of reporting. You should not be asking the question right now. So it is certainly very strange. Thank you, Chairman. And for common reporting standards, some organizations do not have to conduct AOI, and our interpretation is different from that of the OECD. But what about 15L? 50L? We would make clear our main legislation. Deputy Commissioner, can you explain the meaning of the word entity? Amendments were made in the main legislation, including legal person and legal arrangement. So how would you interpret legal arrangement? And this should tally with the interpretation of the OECD. And at some Euro countries such as Belgium, France, and Luxembourg, and they have a legal arrangement. So how would you interpret it? Deputy Commissioner. And the bill mentioned an amendment. Our bill or our law does not clearly define legal person. This is not a common law principle. So, in other words, well, there's no definition or concept of legal person in the common law. So the addition of 50L can satisfy the OECD and show them that we are complying with the requirements. And I see what you or the OECD want now. So it's not hard for me to pass something to OECD, but and our terminology might be different. And we can create something that is very similar to them. And let's say a number of years later, they might say that certain things should be done in a specific way. And we would use the tray that we added provisions under 50L. So I would try to explain this to you. And there's no need to amend the laws bit by bit. And this has not been the government's of the interpretations in recent years. And even if this is not how the government interprets the term, and that the OECD's approach is not followed, and if you are going to claim responsibility, well, it is hard for me to state a case because you are referring to 50L.
So, if that is the case, in the future it might give rise to problems. It would be nice if you're reasonable, but if you're not, then the industry will say, well, I misunderstood, you didn't. Everybody's reading the same laws. If you made a mistake, and even though I made a mistake, but I want to take you to the courts. So if you put it there, that would give rise to that. Mr. Lai? I think I understand Mr. To's concern. Let me try to explain why 50L came about. We are responding to OECD's promotion of common reporting standard. We want to use the same standards to deal with tax evasion. So, as Mr. James Toh said, we don't need to write so much legislation. We could just copy and paste the OECD. That could be one option, but after consideration, we feel that is not ideal. And as our colleague said, the OECD publication, not everything might be applicable to Hong Kong. So if we want to make it convenient to taxpayers and institutions in Hong Kong, we should highlight the applicable parts, and we should express it in language that has been common practice in Hong Kong. So that is our focus. Well, that is not the only way out. Let me give you another option. So the second option is you have interpreted the OECD version that complies with their requirement, and everybody is following suit, but we don't have 50L. Now, if you really made a mistake and we have 5% that are not compliant, so and people find out that 5 years down the road they discover this and they are now complying with again, and I did not deliberately make a mistake. And so people who complied with you, they are familiar with this routine and they are compliant. And now we don't know, should I follow one set or the other set of rules? Then it's very chaotic. So perhaps Mr. Lai explain. Now, if the guidelines are wrong, and the government is wrong, and the taxpayers get it wrong, and if you issue a new guidelines in 2020, so well, Chairman, you cannot settle the dispute this way. No matter what guidelines they issue, so to put it bluntly, I don't make reference to your guidelines, but I would refer to the International Association, the OECDs, and I seek the counsel of overseas experts. So if there's any discrepancy, and I'll be so if 50L is based on two major assumptions. We want to the Hong Kong Inland Revenue has understood the OECD requirements and want to express it clearly in our legislation and explain it to taxpayers. But at the same time, Mr. James Toh's understanding is correct. Our common reporting standard, and when we deal with the automatic exchange of information, in July 2016, we received the endorsement of the LegCo. But on this occasion, this is the second amendment. Why do we have the second amendment? Is because in the 2 years' time, the OECD, when they reviewed our legislation, they felt that our implementation is falling short of their expectations. That's why we have some new amendment requirements. So some of the wording and definitions are updated, and we now are responding to OECD saying we are in better compliance. So it still has to be based on Hong Kong taxation laws, because Hong Kong companies and taxpayers are making reference to Hong Kong tax laws. And that's why we need a footnote saying that the CRS publications are referring to the OECD's requirements. So that's why 50L has stated the two CRS publications, and we state clearly that when we draft our laws, we made reference to the CRS publications. And OECD is satisfied, so legally, in our tax laws, we are aligning ourselves with their official CRS documents and publications. Now, if you look at the 2017 CRS publications, yeah, if there are some new templates or additions, so then our future amendments will, let's say there was a 2023 version, we'll have to make reference to that, and we will propose those. I want to ask, the 50LA, do we have criminal clauses if we have omissions or acts and omissions? Well, for example, if it becomes some acts or omissions can have criminal or non-criminal consequences, then it is not, if it is just a inland revenue action without criminal consequences, but if there are criminal consequences, then we have we have a uncertainty of conduct. Does the legal advisor understand what I'm saying? I think you need to answer that. So in 1A, you have to secure the best between the two, and you're saying, so an act or omission, is it criminal or non-criminal? I don't know what you're referring to. Legal advisor? I see 50L2B, the guidelines. When the courts interpret Part AA related provisions, they must take it into account. When they look at Part 8A related provisions, they must refer to the guidelines published by the Commissioner. So perhaps the government can provide some information after meeting to other jurisdictions to do the same. When the courts interpret the law, the tax laws, they have to consider the government guidelines. Deputy Secretary, let me try to answer. I am in the queue in the security panel. I need to go back to the other meeting. Well, you can excuse yourself, and why don't you answer the legal advisor's question? Well, 50L paragraph 2 says if the person does not comply with the provisions of the guideline, it does not by itself render the person liable to any proceedings. The second question is, to answer the legal advisor, do we have similar provisions in Hong Kong laws? The DOJ colleagues, when they draft the laws, they make reference to other ordinances. And if I remember correctly, it's the Securities and Futures Ordinance has some similar provisions. DOJ colleagues, anything to add on this point regarding the guidelines where they need to be considered? This has occurred in other ordinances, but the specific wordings might not be exactly the same. And as our Assistant Secretary, Deputy Secretary said, doesn't mean that if they don't comply, it will lead to criminal consequences. A legal advisor? I think the in the discrimination ordinance, the Equal Opportunity Commission has issued some guidelines. It is not a legally binding requirement, but the courts can consider the guidelines. So my concern is the wording, is it a must or is it a may? And we refer to interpretation of any Part 8A related provisions. It seems that you are constraining the courts. The courts should be responsible for interpreting the laws. And now you say that when they take this act, they have to refer to the administrative arm of the government. So when the courts interpret the laws, they have to refer to administrative arm guidelines. So I think this is slightly different conceptually. Could you provide a written response after the meeting? I didn't have enough time to find a reference on the internet. Could you provide the information after the meeting? The legal advisor and Mr. To's concern, we can respond after the meeting. You could provide a detailed response why we need 50L, and if taxpayers don't comply, what are the consequences? And your drafting, your version says that if any provision of the guideline appears to the court to be relevant to the interpretation of any Part 8A related provisions, the guideline must be taken into account. Does that mean that the courts have no other options? So you'll need to respond in writing. Any supplements from our officials? So as chairman required, we can provide a written response. Let's continue then. I'll move on to 0032. This is Schedule 17C. The section number, we've added 50L. Moving on 0034, we referred to non-NRFIs. We repealed paragraphs in pages 34 and 35. In page 36, in Schedule 17D, we added some additions, including definitions. 2020 covered institution, new account on page 38, Schedule 17E. We have a table on reportable jurisdictions and reporting year. So I want to ask a technical question. This AEOI, it will be done automatically. We don't need any bilateral agreements, right?
而家全部呢啲地區都要，
其實咧，
全部都要做㗎啦，已經。
如果嗰個
AEOI would be practiced at all these jurisdictions, right? Technically, the arrangement must be activated. Bilateral or multilateral deals could be struck, and certain procedures must be gone through. In recent years, we made a consequential amendment on multilateral or bilateral agreements or bilateral mechanism. Sorry, I mean multilateral agreements. The Central People's Government extended the multilateral agreement on mutual assistance. It was extended to Hong Kong, and some of the provisions include AEOI arrangements. And we also have a multilateral agreement, and this is a multilateral arrangement to facilitate automatic exchange of information. So for the years listed on page 38 and 39 and beyond, do not necessarily mean that by that year AOI can be practiced. They only refer to the earliest years. The reporting years refer to the information of tax residents gathered by the jurisdiction, so the actual year of AEOI might refer to another year. So it only provides a legal basis to gather relevant information of tax residents in different jurisdictions, right? All right. I would move to page 44 of the marked up copy. And this is about the visiting teachers or researchers. We want to avoid double avoidance of tax. So we will add a subsection 1AB. If a person's income is derived from services rendered as a visiting teacher or researcher in the territory outside Hong Kong, and if such persons do not have to pay tax, and if that person is a Hong Kong resident person, then no exemption could be given. So this is to avoid double avoidance of tax, and some definitions will be added. And the existing IRO already has the definitions on double taxation arrangements, Hong Kong resident person, as well as visiting teacher or researcher. Page 46, allowances. These include dependent brother or dependent sister allowance. At a recent IRO amendment, we saw inadequacies to the definitions of dependent brother or dependent sister allowance, and this is a consequential amendment. Page 0048 are transitional provisions. So barring any questions, that's all for the clause-by-clause examination. Any questions from members on the clause-by-clause? Legal advisor, please. On page 0050, the second item under transitional provisions, the tax treatment of financial instruments. The date of enactment is the year of assessment for which the basis period begins on or after the 1st of January 2018. The government clarified that this is not a retrospective tax collection treatment. So we would now talk about the CSAs. This is CB 1241 18 to 19 brackets 01 or 410 brackets 01, and in paragraph 2 of the paper we wrote that we would offer flexibility on the fair value basis apart from the Hong Kong reporting standard number 9 and the IFRS 9. Any accounting standard equivalent to IFRS 9 adopted by a foreign jurisdiction to the satisfaction of the commissioner, it would be accepted. And this would be conducive to our tax assessment work, and there would be consequential amendments in section 18G brackets 1 and again and likewise for 18L. And section 18 includes the removal of a word in the Chinese text, and in section 18G brackets 2 brackets B, the Chinese term 有關條文 does not exist in the English text. For the Chinese text, since other sections are already quoted, we felt that removal of this term would aid understanding. So we amend removing this tag definition. And in paragraph and in clause 4 for governmental entity, since there's an existing definition under section 50A brackets 1 of the IRO, we would seek to align the definitions. At the last meeting, the chairman and members raised views that the IRO is often amended on a yearly basis. We promised to add in the heading of the IRO the key areas of our work instead of just naming the amendment bills number 1, number 2, number 3, etc. We intended to amend the heading of the bill in this manner, but after discussion with the Secretariat, this might not be in line with Rule 50 of the ROP. The title of the bill cannot be renamed. So for future Inland Revenue Amendment bills, we would adopt a new arrangement. Legal advisor? For the first amendment on specified financial reporting standard, there will be a new section referring to reporting standards by other overseas authorities. So the relevant authority is cited in the blue bill. Sections 1 and 2 refer to the Hong Kong ICPA and the IFRS. So currently there's no definition for the relevant authority. Is there a need to explain what this is about? For instance, their functions are similar to the bodies mentioned in sections 1 and 2. In AML ordinances in CAP 615, there's a similar situation. The Hong Kong authority and overseas authority are defined, and the overseas authority is defined as an authority exercising a function similar to the Hong Kong authority outside of Hong Kong. So is there a need to define or clarify the term in the bill? Thank you. DOJ. For the relevant authority, when we look at the text of the CSAs, it is used to specify the financial reporting standard. If we are to specify the bodies involved, well, we might be going around the circles, and it would not help offer any additional information. So we do not feel there is a need to state that the function of such authority is equivalent to the Hong Kong Financial Reporting Standard Committee. this would not offer any extra information. So the authority must have the power to issue financial reporting standard. So for bodies exercising other functions, for example, overseeing insurance companies, they would not be a relevant authority. So legal advisor, any other views? No. In the context of items 1 to 3, I think the case is clear. Mr. Lai talked about the long title for bills. Yesterday at another bills committee meeting, apart from the title, I hope to retain the amendment number in the bill. So I'd like to see how much work your department has done, and the same applies for bills from other bureaus. So for FSTB amendment bills in the future, especially inland revenue amendment bills, apart from the scope and objective of the bill, the amendment bill number should be retained, and you can think about whether the number would be bracketed or inserted elsewhere. DOJ, do you have any views on that? Thank you. We understand that the inclusion of a number in the title of the bill would offer more information. But having considered the fact that the title of the bill is a label and the main function is to differentiate it from other bills, so a shorter title for the bill would make it more readable. So if the bill title is already descriptive, if we include the number as well, it might be somewhat long. I think we don't mind having a long title, so please give this some thought. We don't mind having long bill titles at all. We would consider this. Even if this cannot be done in the LegCo, in the paper shared with LegCo, we would highlight the number of amendments made in the year.
So looking ahead, regarding 50L, the government will give us a detailed response. I will circulate the response to other members, and in your response I will see if you have highlighted any important issues. So if it gives rise to basic issues, I have set aside another meeting date, and I don't think it will be too long. It is Tuesday, 8:30 morning, 22nd of January, 8:30 in the morning. If we receive your response, and if we all think there's no need for a discussion, then I will have another schedule. If there is no need for further meetings, I expect on the 25th of January 2019, I will be reporting to the House Committee our report, 25th of January. And if I can report to House Committee on 25th of January, then on the suggested date of 20th of February, we will resume the second reading debate, and if according to this schedule, then the deadline for CSAs is 11th of February. And the government resumption of second reading debate deadline will be 1st of February. And on the 20th of February, if the government wishes to submit it for a resumption of second reading debate, we'll have to await your response. I want to ask members if they have any other business that they wish to handle. If not, then we can adjourn the meeting. Thank you.